We challenged the constitutionality of the central bank bill before the Supreme Court under the case number SD 9/2023 because it has grossly violated Article 3 and 4 of the Constitution in my opinion, and therefore it cannot be a law without obtaining the approval of the people at a referendum. Reportedly, enactment of this bill is a precondition of the IMF to obtain their facility. If there is a conflict between the Constitution and the IMF agreement, Constitution cannot be amended to accommodate the IMF agreement. Instead, IMF agreement should be suitably be amended to comply with our Constitution. In terms of Section 4 of the bill, central bank is fully owned by the government. It means public funds have been invested in this institution. However, Section 5 says the central bank shall have financial and administrative autonomy. How can a public institute exist without the government control? We know both the executive and the legislature has to be sensitive to people's aspirations and welfare because they have to go before the people for re-election in every 5 years. On the other hand, the opposition and the media are very much watchful of activities of the government. But in the central bank's case, people have no opportunity to appoint these officers or remove them if people don't want them to be in that office. Because of that, if we lose the government grip over the central bank, it means central bank can be controlled by other forces, or firstly they may act as they wish, or in a worse scenario, central bank will be controlled by Western embassies and the IMF. Therefore, crucial public institutes like the central bank must be within the people's radar. In terms of Section 7 of the bill, central bank is the banker, financial advisor, and the fiscal agent of the government. Section 6 says the central bank shall support the general policy framework of the government. These two sections reflect the interwoven and crucial roles of the central bank, who formulates the monetary policy, and the treasury, who formulates the fiscal policy. That is why Treasury Secretary becomes a member of the Monetary Board ex officio. Treasury Secretary becomes a member of the Monetary Board ex officio, acknowledging these crucial relationships under the prevailing law. Unfortunately, the proposed law denied that opportunity to the Treasury Secretary, giving a seat in the governing body to the Treasury Secretary, and as a result, the essential link between the central bank and the government has been severed by this bill. These are among other reasons for us to challenge this bill before the Supreme Court.